Good afternoon. Thank you for joining this webinar. We will be dealing with the issue concerning child custody, child maintenance, and divorce. It's a usual chat. I usually have Felicity and guests with me today. Today I'm dealing with the matter on my own. She will join us at the next webinar. So, moving forward, previously many people asked questions regarding child custody, child maintenance, and divorce. Today I will try to answer as much questions as possible. When I answer these questions, I generally deal with it on the basis of what I have been experiencing for the last few weeks. What type of questions came to my desk over the last few weeks? What's relevant? Of course, the most relevant issue regarding child maintenance is, should a parent continue to pay child maintenance notwithstanding the lockdown? Obviously, the answer should be simple. Of course, you must pay, but there are obviously complications that comes with it. Parents might have been retrenched. They may have lost their jobs, earning much less, etc. If you are watching this live webinar, it is streaming live on Facebook pages. Please post a question on the following Facebook page, the Advocate Mohammed Abduroaf Facebook page. If you post it there, I'll be able to see it and I will be able to answer it immediately. We have created a redirect link, www.abduroaf.co.za/live. You can see it on the screen. Please make sure that you are using the Advocate Mohammed Abduroaf Facebook page to pose a question, and I will try my best to answer it. So let's move forward. On the issue concerning child maintenance, I have been discussing the issue regarding child maintenance during the national lockdown. I will quickly summarize it. Basically, you have to pay child maintenance even if you lost your job. Unless you can tell me you lost your job, you do not own anything, you do not own a pair of shoes, you do not own a cell phone, you do not own sunglasses, you do not own any clothes. If you own something like that, please sell it and pay child maintenance or contribute towards your child's food and clothing. I had a few queries where people asked, I am paying 500 Rand per month. My salary is 10,000 Rand per month. I'm paying 500 Rand per month. I can only afford to pay 500 Rand. That's what they're basically telling me. So I asked him the question, are you saying that your child costs about 15 Rand, 16 Rand per day to survive, which should include clothing, food, accommodation, and so on? Obviously not. Make a plan. Try to pay more child maintenance. Your child requires it. I can't see how can a child survive with 15 Rand per month. If you are saying the other parent should also contribute 15 Rand per day. If you are saying that the other parent should also contribute 15 Rand per day, then what are we saying? A child costs 30 Rand a day. It's not a lot. There's breakfast, there's lunch, there's supper, there's school fees, there's clothing, there's transport, and so on. Therefore, you might not be earning much money during the lockdown. You have assets, sell it. If you own a car, sell the car, pay the child maintenance. And at the same time, if someone is paying adequate child maintenance, wonderful. You can do whatever you want to do with the rest of your money. You can travel the world, you can buy whatever you want to do. But as long as you're paying adequate child maintenance. So those of you who are online watching this webinar, please feel free to post your question. And if you are watching this video, feel free to share it as well. Let's deal with the topic at hand: child custody, child maintenance, and divorce. On the issue regarding divorce, the first issue that you have to resolve is your matrimonial property regime. You have to determine how you are married. So let's take it a few years back, or step back, if I may say so. Those people who are intending of getting married, sorry about that, they need to determine beforehand what matrimonial property regime they are going to enter into. For example, income into a property where there is one pot, one joint estate. If a spouse comes into the marriage with debt, that debt automatically forms part of the joint estate, and therefore the other spouse will have an obligation also to repay that specific debt. And whatever assets that comes into the picture, that those specific assets belong to the joint estate. So it's the positive and the negative. The assets and the debt, it all comes into one. Creditors will obviously go ahead and claim the money from one specific spouse who incurred that debt either before or during the marriage, but the the item or the entity that will have to pay the debt will be the joint estate, and it will come from both parties' money. So that is quickly income into property. Then you are welcome to get married out of community property with two possible scenarios, with the inclusion of the accrual regime and with the exclusion of the accrual regime. The accrual regime basically means that whatever growth, whatever assets the parties have acquired, whatever wealth they have acquired during the marriage, they have to share. They have to share in the division thereof. So if a husband came into the marriage with nothing and the wife came into the marriage with 1,000 rand, at divorce he is now worth 1,000 rand and she is worth nothing, then he will have to pay her 500 rand. There's certain ways to calculate this, but that's basically the principle. So a wife can be at home all the time. She can support a husband can go to work, he can travel the world, he can make lots of money, he can become extremely wealthy. But because they are married with a accrual regime, should they get divorced, she will get half of that specific wealth which she has accrued or acquired during the marriage. So the wife would not be left out. If the parties are married out of community property with the exclusion of the accrual regime, it's basically as if they were not married when it comes to the property aspects of the marriage. They are married out of community property. What his is his, what hers is hers. At death or divorce, there's nothing to discuss. They continue. During the marriage, if they are married out of community property with the accrual regime as well, or excluding it, if one party gets sequestrated, gets into financial difficulty, as the case may be, only his or her estate will be affected thereby. I see we have a question. The person posed the question on the watch party. What if they refuse to pay and keep using unemployment as an excuse? Thank you for that question. If a parent does not want to pay and keeps on using the excuse of being unemployed, I will still take the person to the maintenance court, and he or she will have to explain to the court, and the court will have to be convinced that the party is trying their best to obtain employment. The maintenance court will have to give them some type of documentation where they can prove that they went to various places to apply for jobs. If that person cannot really find a job, then go one step further, go against his parents, because I'm not really concerned about who pays the money. If it is the father or the mother or the grandparents, whatever the case may be, as long as the child receives the much needed child maintenance. So if a parent keeps on saying, I cannot afford to pay the child maintenance because I am unemployed, obviously that parent is eating, has clothes on their body, moves around, and so on. It's unacceptable for one parent to say, I cannot afford to pay child maintenance because I'm unemployed, but I am eating every day, I have a roof over my head, and so on. But my child, it's fine, he or she will just live off oxygen and water. That's totally unacceptable. Take that parent to task. He or she must apply every single day for a job at many places. If he or she cannot really find a job, that is obviously then a factual thing. It must be considered. But I do not accept a parent coming to me and saying, I cannot find a job. Then sell whatever you have. Do something. Work as a packer, as a cleaner, whatever the case may be. There is work available, or there should be, or I'm certain even make an effort every single day and climb down your ladder, your whatever ladder you think you are entitled to earn. Move down the ladder. If you're used to earning 100 rand per month, be happy with 5 rand per month and give 250 to your child. Your child requires a maintenance. If there is anybody else that has any further questions, feel free to pose it and we will try our best to answer it. Regarding the issue of child custody, to summarize again, we have dealt with this extensively in our previous webinars. People come to us and they say, I would like to have child custody. I would like to have custody over my child. And the reason for that is they have problems at the schools where the school requires both parents' signatures. If the parent wants to apply for a passport for the minor child, they require both parents' signatures for relocation, whatever the case may be. It's not custody. Here we're dealing with the issue regarding guardianship. It's very important that you understand the difference between guardianship and custody rights. Guardianship refers to the legal aspects of a child's life. Legal in the sense of, let's say, a passport application, nothing to do with visitation. The child purchasing immovable property. Let's say a child wants to purchase a home or sell a home and stuff like that. Immovable property, a house, you require both guardians' consent. The child may want to perform an operation, require guardian's consent, apply to a school guardianship consent. It has nothing to do with the visitation rights. Custody, on the other hand, deals with the day-to-day caring of a child. A child will reside with one parent. That parent will be the custodian parent for the child. The other parent may have no guardianship rights, where the one parent caring for the child will have all those specific rights. Or we can have a scenario where a parent is not allowed to have any contact with a child, or contact once a year, once a month, as the case may be. But that parent has co-guardianship rights. The parent cannot see the child or sees the child under limited circumstances or very few days per year, but he or she has co-guardianship rights. He or she will have to give consent when it comes to issues concerning his passport, maybe school applications, and so on. We have a question. When a mother gets a new boyfriend every 6 months and they move in with her, can a dad try to get custody? The boyfriends are allowed to give the child hidings. It's a very important question, and thank you for posing it. The question like that basically has two sides to it. You have to weigh it. We are saying the mother has custody, of course. Every 6 months she gets a new guy in her life, and she lets a guy into the house, and the guys give the child a hiding if the child is naughty, I don't know, but they're acting as almost as if they are primary caregivers over the child. Now the question is, can the father by default get custody over the child? Now, it doesn't mean that automatically if the mother is dating many guys and bringing other people into the house, automatically means that the father is capable of caring for the child just as well as the mother is capable of caring for the child. The mother might be an extremely good caregiver, educational wise, where the child is ill, rearing the child, but her problem is having too many men in the child's life. If that is a problem according to the specific person, I'm not judging anybody. Does it automatically mean that because of that, the father should automatically have custody over the child? That is a bit of a far leap. The question is, can the father care for the child? Has he ever cared for the child? Has the child ever overnighted by the father's home? What are the circumstances in the father's home? Does he have a new woman in his life? Does he have another person in his life? Is his home adequate enough to care for a child? It's difficult to answer these type of questions in isolation, and I cannot do that. That's why a court would usually appoint a social worker, the Office of the Family Advocate, or a child care expert to assist in dealing with these type of matters. The same way, for argument's sake, a client might come to me and say, I'm paying 100% of the child's maintenance. I'm paying for all the school fees, all the medical costs, and so on. Does that automatically give me rights of custody over the child? The answer is no. Child maintenance and child custody issues are two separate issues. The same way, if a father is paying no maintenance towards a child because he cannot afford to pay child maintenance, it's possible for him or her to have adequate contact with the child every second weekend, during the week, half school holiday, etc. And in the same way, if a mother is not earning any money, cannot afford to care for the child, she has no money, etc., does that automatically mean now that the father should care for the child because he has the money? So these are separate issues. Yes, if the father is capable of caring for the child, just as well as a mother is capable of caring for the child, as our question on Facebook, our live question on Facebook, and the children are being neglected when in the mother's care, these boyfriends that she brings into the house every 6 months is a bad influence on the household, on the upbringing for the minor child, psychological well-being, etc. And it would be best under all circumstances to put the child in the primary care of the father because of that. Then you can bring up a case. But if the mother meets a different person every 6 months, dates a different person every 6 months, brings them into the home, and one of them starts giving the child a hiding because he or she is naughty, I cannot by default say that is good enough reason. We have to look at the matter holistically. The person added another comment on Facebook Live. It says the following: the father got remarried and they can give the child a very stable life and home. The child loves to be with the father and his new wife. The father is definitely capable of taking care of the child. Okay, wonderful. So we have a situation here where the father is alleging he can care for the child. There's a new home, stable environment. It seems to be much better than the mother. Can we judge the mother just because she meets someone every month, every 6 months? Automatically doesn't mean that if you meet someone every 6 months and the person moves in and there's a child involved, does it automatically mean that person is incapable of looking after the child? What I would suggest here, the father seems to be a good candidate. There are no social welfare issues against the father for caring for the child. If an expert gets on board and as expert consults with the mother, investigates her circumstances, consults with the father, investigates his circumstances, consults with the minor child as well, and investigates her circumstances, and know that the father would like to care for the child. And if the expert, the child care expert, the social worker, psychologist, psychiatrist, whoever they get to make use of here, is of the view that if the child lives with the father under the new circumstances, it will be better for her because the schools are close by, he can care better for the child, the mother's situation is not as good, then you can bring out a very good case. So the question is not necessarily a legal question. A legal question, it can always go yes or no. It's more of a professional, a child care expert type of question. What do they presume? If someone came to my office with a report from a child care expert stipulating, I have assessed the entire matter, I have assessed the mother, I have assessed the father, and in my view, it would be best for the child to live with the father. Wonderful. I would, from a legal point of view, put my legal cap on and start fighting for the father to have primary care over the child. The Facebook Live comment goes further. The mother also forced the child to call one of her boyfriend's dad. My point again, does it automatically mean if a mother tells one of the boyfriends, call her boyfriend dad, does that automatically mean now the kids must move to the father? There are millions of points, millions of issues to look at, and you cannot look at this matter in isolation. You need to look at this matter holistically, because no family is perfect. It's impossible. The father will never be perfect, the mother will never be perfect, the kids are also never perfect, and so on. Are we saying tomorrow the mother and the father has an argument, the father, for argument's sake, lifts his hand at the mother? I'm talking about the step parents. I'm using a fictitious example, and they swear the child, whatever the case may be, or the stepmother gives the child a hiding because she's naughty. Does it automatically mean now the kids must not start living back at the biological mother? We need to look at this matter holistically. What is best for the child, considering the imperfect parents, because all parents are imperfect. No parent is perfect. The imperfect child, and then based upon that, what would be best for this child? If you have any questions, I hope I've answered the previous question adequately, but if you have any further questions, please feel free to post it on Facebook Live, and we'll try our best to answer it. On the issue regarding child custody and guardianship, when dealing with the issue regarding child custody, the first thing you have to determine is what is best for the child. I mentioned it earlier on regarding that example, but let me just continue with this issue. What is best for the child? Is my ego best for the child? What I want? Or is what's best for the child really what is the case? Is it best for the child to live with the mother, or is it best for the child to live with me, the father? Or is it best for the child to live with a third party? Because that is also possible, because the Department of Social Welfare will get on board, and if neither the mother, neither the father can look after the child, then clearly the child must go to foster care, or a third party must look after the child. So that's very important. The difference between guardianship and custody rights, important issue. A parent will usually enforce that specific rights or apply it when the child would like to apply for a passport, the minor child, and the other parent says, no, I would not want to consent thereto. Then you'll approach a court, and the court will now, as upper guardian of all minor children, enforce or make a decision as to what is best for the child. What often comes to our office is the issue concerning surname changes, whereby the minor child might have one parent's surname, and the other parent believes, no, the child must have my surname. Those are also guardianship issues where both guardians basically will have to give consent and so on. If you figured out the difference between guardianship rights and custody rights, then you'll be in a very good position to proceed in dealing with your child custody issues that you may have. A parent that has guardianship rights over the child can assist a child in legal documentation. If a minor child wants to purchase some type of thing, let's say a bicycle on his or her own, the guardian can assist that minor child. So that's where guardianship comes in. All basically legal aspects regarding a minor child. We have another comment. Let's go there. How does it work if a father is in arrears and he is self-employed? Not all the money he gets is put into his bank account from the customers, but a lot of it is in cash. How does the court sort this arrears out then? The typical scenario where somebody is self-employed, he or she gets paid via the bank, the invoice the client EFTs him, and the other scenario would be whereby he or she does work and the client pays him via cash. The cash does not get recorded anyway, but obviously what gets paid into the bank account gets recorded. And sometimes, I'm not saying this is a scenario, when it deals with SARS and so on, the tax returns only reflects what happens in the bank account and not necessarily what happens under the table or via cash. In this specific questionnaire here on Facebook Live asked, there is a court order in place, this person is in arrears, but the person is obtaining money by cash, and maybe if he discloses that specific cash, he can use that specific cash to pay for the arrears. I would actually advise, firstly, if somebody does not want to pay child maintenance, he or she will try his or her best not to pay, and by hiding income, hiding expenditure, or maybe inflating expenditure and so on, in order not to pay child maintenance. That is a plan. I would say go to the maintenance court as soon as possible, lay a complaint for non-compliance with the maintenance order. Either it will go through the criminal route or via the civil route, will try to garnish his stuff or attach stuff. He is a business owner. Obviously, there's certain type of assets that he has in the business. Those specific assets can be sold and realized in order to pay the real maintenance. It's difficult because if there is no money to be found, let's say you know this person has money, this person is hiding money, but in front of the maintenance officer or the maintenance court, there is no evidence. You have this allegation. You say, while I was married to this person or while we were together for 5 years, every day he used to come home with thousands of rand in cash, put it in his cupboard, use it to pay for various expenditure. Now the parties are separated. It's 5 years later. You make the same allegation to the maintenance officer. The party who is supposed to pay says that's not true. It was a once-off thing, as the case may be. So you know this person is acquiring a lot of money via cash, not disclosing it. You need to still prove it. The one example which I like using is if somebody is a taxi driver, obviously all the money is cash. I'm talking about the public taxis. Nothing gets done via EFT. You need to find someone that can assist you in determining how much money does that specific parent make via the taxi rank. How many trips does that person do? How much expenditure does a person have, and so on. You'll be able to work out exactly how much that specific parent would be earning. Ask colleagues of that person. How much do they presume is earning based upon doing the same route, and so on. So if the parent says, no, I only earn while I'm a taxi driver an amount of 500 rand per month, that is something else. You can't say that unless, you're disputing it. So he or she says, I'm earning 500 rand per month. You're disputing it. You need to come to court and prove that he or she is earning much more money. One logical way of doing that is obviously to say, how can you earn 5,000 rand per month, but you are spending so much money on this and that and that and that. Your other kids go to this specific school. So you're disproving it with evidence, with factual evidence that is before you, before the court. But if you want to say that he is actually earning maybe 20 or 30,000 per month, you need to do that research. You need to find people to assist you. The maintenance court, all that they could possibly do is ask him questions, maybe do some checks via his bank account, check up on SARS, do ITC checks, credit record checks, and so on. But if you cannot prove your case, and all that you are making is a bold allegation based upon things that happened 5 years ago, I doubt that you will be successful in your claims. The same way the father can do the same, or the other party can do the same. Say, no, she earns so much money, although he never earned so much money. He can say she has a sideline job. She earns so much money every month, and she earns so much money while we were together. He can make that allegation, but if he cannot prove it, obviously it should mean nothing. The same way if you make those allegations regarding a parent's ability to pay child maintenance, or the parent is now hiding money and so on. So to the specific person, it's a very difficult scenario to deal with. If there is no proof that there is money, what can you do? You need to convince the court that there is money. As I mentioned early on at the start, proceed to the maintenance court, lay a complaint of non-compliance with the maintenance order. That should be of much use to you. If there are no further questions on Facebook Live, we have another 5 minutes for this webinar. Feel free to pose it. I will try my best to answer it in depth as I've done now. And feel free to share this video. Somebody might find it useful in the future. Concluding on the issue regarding guardianship rights, when you're applying in the children's court, in the custody court, etc., there is a standardized clauses stipulated in parenting plans, in consent papers, in divorce orders, and so on. Make sure that you understand it. That if one parent has co-guardianship rights over you, there are legal implications involved. The other parent may see the child only once a month, once a year, as the case may be, or maybe never. But if that parent has co-guardianship rights over the minor child, you will always have to consult and get the other party's consent when it comes to the minor child. As I mentioned earlier on, passport application, some schools require both guardians to consent, and so on. Then we go to the issue regarding divorces, as I mentioned earlier on. A court can only divorce someone if the marriage has broken down irretrievably. Irretrievably means basically that the marriage cannot be saved. They tried everything. They went for counseling, maybe. They spoke to some people, or they were separated for the last 5 years. Of course, that marriage has broken down because each party went on with their lives. A court will not divorce a couple unless the court is convinced that the marriage has broken down and the marriage cannot be saved. That's the one aspect. That's for the divorce. A court will also not divorce anybody if the court is of the opinion that, the court will not divorce somebody unless the issue concerning child maintenance, child custody has been resolved. The court will apply his or her mind to that. The other aspect regarding financial implications, matrimonial property regime, pension funds, accrual, and so on, the court isn't concerned about that because that is between you, the husband, and the wife. That's their issues. The husband can sign everything away for the wife, saying you can have everything, you can have all the pension, you can have all the accrual, whatever the case may be. The court will happily endorse that. But when it comes to issues regarding child custody and child maintenance and so on, the court will have to be convinced that those specific arrangements are in the minor child's best interest. Therefore, all custody orders, all consent papers, all parenting plans will have to be endorsed by the Office of the Family Advocate in order for a third party, an expert, to look at it and to give the court a decision or recommendations as to whether or not the parenting plan should be made an order of court. And many times it comes where the Family Advocate's Office, they will make certain comments. Please allow oral evidence on the following points, whatever it may be, in order for the court to be convinced that the minor children's best interest has been fulfilled. Thank you very much for watching this video, this webinar. If you found it useful, please share it. Someone else might find it useful and be able to gain from some of the questions that were posed. Those people who have posed questions live, thank you very much for that. And we hope to see you next week. Thank you. Bye-bye.